In this video we read the Google Ads program terms verbatim. Please take the time to listen. These advertising program terms, hereinafter referred to as the terms, are entered into between Google Asia Pacific Private Limited, hereinafter referred to as Google, and the entity implementing these terms or the entity accepting these terms electronically, hereinafter referred to as the customer. These terms govern customers' participation in Google's services and advertising programs, which may be accessed through the accounts granted to customer in connection with these terms or which integrate these terms by reference, collectively, the programs. Please read these terms carefully. These terms require the use of binding individual arbitration to resolve disputes rather than before a panel or class action. 1. Programs. Customer authorizes Google and its affiliates to place advertising materials, up-to-date data from customers' data sources, and technology, collectively, advertising or advertisement. Creation, on any index or online tool, collectively, an online tool, provided by Google or its affiliates on behalf of Google or, as appropriate, provided on behalf of a third party, hereinafter referred to as partner. Customer is solely responsible for all ads, decisions to sell or target ads, for example. Keywords, hereinafter referred to as targets, destinations that ads directing viewers there, e.g. landing pages, mobile applications, with associated URLs. Landmarks and redirects, destinations, and services and products. Advertised on the destination, hereinafter collectively, the services. The program is an advertising platform whereby customer permits Google and its affiliates to use automated tools to format the ads. Google and its affiliates may also provide certain optional program features to customer to assist customer in selecting or creating targets, ads, or destinations. The customer is not required to authorize the use of these optional features and, as appropriate, may subscribe to or unsubscribe from the use of these features. However, if customer uses these features, then customer will be solely responsible for the targets, promotions, and destinations. Google and its affiliates or partners may refuse or remove a specific target, ad, or destination at any time for any reason or no reason. Google and its affiliates may modify or cancel the programs at any time. Customer acknowledges that Google or its affiliates may participate in program auctions in support of its services and products. Certain program features are identified as beta, or otherwise secure or unsupported, collectively, beta features. Customer may not disclose any information from the beta features or the terms or existence of any beta features that have not been made available to the public. 2. Policies. Customer is solely responsible for its use of the programs, for example, accessing and using program accounts and protecting usernames and passwords, hereinafter referred to as uses. Use of the program is subject to applicable Google policies posted at www.google.com/ad/policies, and all other policies as notified by Google to customer, including policies for partner. And where applicable, the EU Google User Consent Policy at privacy.google.com/businesses/user consent policy, in each case, as amended from time to time. Points. Hereinafter referred to as the policies. Customer also authorizes Google to modify the advertising items as described in the policies. In connection with the program, Google will comply with the Google Privacy Policy posted at google.com/policies/privacy, as amended from time to time. To the extent that use of the program is covered, Google and customer agree. As applicable, to the Google Ads Controller, data protection terms at privacy.google.com, businesses, controller terms. or the Google Ads data processing terms are available at privacy.google.com/businesses/processorterms, collectively, the European Union Data Protection Terms. EU Data Protection Clause. Excluding program. Expressly permitted by the European Union Data Protection Clauses. Customer will not, and will not permit any third party, to generate, fraudulently or otherwise, make automated, fraudulent or otherwise fraudulent impressions, requests, clicks or conversions, conceal conversions of the program. When necessary to disclose, use any automated means or form of data collection or extraction to access, query, or otherwise collect information related to Google's advertising from any online tool unless expressly permitted by Google, or attempt to interfere with the operation of the programs. Customer will transmit communications regarding advertising items on the partner's online tools under these terms only to Google. 3. Implement advertising. A. Customer will not provide ads that contain or link to malicious software, spyware, unwanted software or any other malicious code or are known to infringe or break any program security measures. B. Customer may use the advertising server only for the purpose of delivering or tracking advertising items under the programs to enable third parties to execute ads and only if the advertising server has been approved by Google. Permission to participate in the program. Google will install customers' ad server tags for them to work. C. For online display ads billed on a CPM or VCPM basis, hereinafter referred to as display ads. If Google's actual impression count, hereinafter referred to as IC, for a program that is 10% higher during the billing period than customer's third-party ad server IC, hereinafter referred to as 3PAS. Customer will support reconciliation effort between Google and 3PAS. If this deviation is not resolved, the sole remedy available to the customer is to file a claim within 60 days of the invoice date, claim period. If Google determines that the claim is valid, Google will send customer an ad credit equal to 90% Google IC minus 3PAS IC, multiplied by the average CPM or VCPM of the campaign. Reporting by Google, as applicable, during the billing period. Customer must use any advertising credit granted within 60 days from the date of issue, but use term, and Google may suspend customers' use of such 3PAS provider and may suspend the use of such 3PAS provider. Indicate or invalidate the deviation provisions set forth above in this section for that 3PAS provider. The metrics from 3PAS, to which these 3PAS ad server tags are provided to Google, will be used in the calculations to resolve the bias mentioned above. Google may require 3PAS to provide records of such deviation directly to Google. No credit will be given to customer for deviations due to 3PAS's inability to implement the promotional items. 4. Testing. Customer authorizes Google and its affiliates to periodically conduct tests that may affect customers' use of the programs, including the advertising format, the goals, the points arrivals, quality, ratings, performance, price, and auction time adjustments, to ensure the timeliness and validity of test results. Customer authorizes Google to perform such tests without notice or remuneration to customer. 5. Remove ads. Unless a policy, the program's user interface, or an agreement to refer to these terms, hereinafter, IO, provides otherwise, either party may cancel any ad item at any time prior to an earlier date between auction time or ad placement. But if customer cancels an ad after a commitment date specified by Google, e.g. such as a reservation-based campaign, customer is responsible for any cancellation fees that Google notices to customer, and ads may still be posted. Cancelled ads will generally stop showing within 8 business hours or as described in the policy or IO, and customer remains obligated to pay any fees resulting from the promotions implemented, e.g., conversion-based fees. Customer must perform the cancellation of online advertising items via customer's account if a cancellation feature is available. If the cancellation feature is not available, it must notify Google by email to customer's account management representative, or, if ad cancellation is not available and customer does not have an account management representative, then notify Google by email to ads-support@google.com, hereinafter referred to as the ad removal process. The client shall not be released from any payment obligation in respect of the advertisement not sent or sent by customer after the due date specified by Google. Google will not be bound by an IO provided by customer. 6 warranties, rights, and obligations. Customer warrants that a customer holds, and hereby grants to Google, its affiliates and Google partners, the rights to the advertisements, destinations and targets to Google. Affiliated companies and Google partners operate the Google programs, including, in the case of data source updates, after customer discontinues use of the programs. And b. All information and authorizations provided by the client are complete, accurate and current. Customer authorizes Google and its affiliates to automate retrieval and analysis, and to create test credentials to access destinations for programs purposes. By providing any mobile or other phone number to Google in connection with the programs, customer authorizes Google, its affiliates, and on behalf of Google and its affiliates Google calls and text messages, standard charges for data use or messaging may apply to the phone numbers provided, including by automated phone dialing, for purposes of the programs. However, Google will not rely on this permission to make auto-dialing calls or send text messages for marketing purposes. Customer further authorizes Google, its affiliates, and on behalf of Google and its affiliates to send email to customer for the purposes of the programs. Customer warrants that it is authorized to act on behalf of, and to be bound by, these terms, for each third party, if any, to which customer advertises to them in connection with these terms, hereinafter referred to as the advertiser, and any references to customer in these terms shall also apply to the advertiser. As applicable, if, for any reason, customer fails to bind the advertiser to these terms, the customer will be responsible for performing any obligations that the advertiser would have to perform under these terms if they be bound by these terms. If customer is using a program for advertising on its own behalf, then for such use customer will be treated as both customer and advertiser. Customer will provide advertisers with reporting data no less than once a month showing the exact amount spent on Google and advertising performance with a minimum of cost, clicks and user impressions on that advertiser's account in a reasonably prominent position. At the request of the advertiser, Google may share specific information about the advertiser with the advertiser. 7. Compensation. For reservation-based display ads. By the end of the campaign, Google will complete display for the total agreed number of display ads, but if Google fails to do so, then the only remedy available to the customer is to file a claim within the claims period. If Google verifies the accuracy of the claim, then Google will not charge customer for undelivered display ads, or if customer has already paid, in Google's reasonable discretion, Google will apply the option of granting advertising credits, which must be used by customer within the term. Place the display ads in a position that Google deems appropriate within 60 days from the date Google confirms the validity, accuracy of the claim or extends the term of a campaign. Google cannot guarantee that any auction ads will be fulfilled, and therefore compensation does not apply to ads Reported by auction. 8. Payment. Customer will pay all costs incurred in connection with the program, using a payment method approved by Google for such customer, as amended from time to time, within a commercially reasonable period of time, specified by Google, for example in the program user interface, or I/O. Late payments will be subject to interest at an interest rate of 1.5% per month, or the maximum permitted by law, if the highest rate permitted by law is lower than 1.5%. Fees do not include taxes. Customer shall pay all taxes and other government levies and reasonable costs and attorney's fees incurred by Google to recover undisputed late payments in a fair manner. Honest. Charges are charged based on applicable program billing criteria, for example, based on clicks, impressions, or conversions. Any portion of the fee that is not honestly disputed must be paid in full. Neither party may set off any amount due under these terms against any other payment to be made under these terms. Google may, in its sole discretion, extend, adjust, or revoke credit at any time. Google is under no obligation to display any ads in excess of the credit limit. If Google fails to render the ads for selected targets or destinations, the sole remedy available to customer is to make a claim for advertising credits within the claim term. Indemnification. Then Google will issue credits after validating the claim, and such credits must be used within the term. Customer understands that third parties may generate impressions or clicks on customers' ads for prohibited or illegal purposes, and if so, the only remedy it is best for customer to make a claim for advertising credits within the claim period, after which Google will issue the credits once the claim has been verified, and such credits must be used within the term. To the most comprehensive growth permitted by law. A customer warrants any claim into any plan of fees unless comprehensive company responsibilities normal, and b. the issuance of advertising credit, if any, is totally responsibilities to Google in. If allowed, these advertising credits must be used for life. 9. Disclaimer of responsibility. To the most comprehensive general accessories permitted by law, Google. Representatives for myself and Google's partners and associates. Disclaimer for an exclusive. All disclaimer, all disclaimers, all disclaimers, all warranties and warranties, what implied. Mandatory OR other type, includes for non-violation, quality satisfaction, merchantability and compatibility. Company any implied terms growing from any trading OR trade use that is not disclaimer in this agreement. To the most comprehensive growth permitted by law and except expressed in this agreement. Online tools of the programs and Google's affiliated companies, and the company cons given, as available, and, with all errors, and customers use this online tools at the full risk of the customers, and of any promoter, responsibilities, and both Google and Google Associates OR partnerships do not make any warranties in related to the program or the program results. To the most comprehensive tool permitted by law, Google does not be committed to notification of customers about defects or errors. 10. Limitation of liability. Except Section 11 and customers violations in Part 3 of 14 or final sentence of Section 1, for the most complete scope permitted by law of any law and claim. Both Google OR customers OR Google and customers correlative affiliated companies shall not be liable under these terms OR arising from OR related to the court this for any damage except direct damages. Even if the party or knowledge OR should know that different types of damages and other types of difference are always aware meet a repair. And b. outside the customers paying obligations below by these terms. Both Google OR customers or Google's OR customers' personal links are responsible for responsibilities. This term's OR arises from OR in connection with the implementation of these terms for any specific event or continued blood of events for other countries of this terms Google under the terms for 3rd days before the day of first action leading to the claim. 11. Reimbursement. Customer will defend and indemnify Google, its partners, agents, affiliates, and licensors from all liabilities, damages, losses, and liabilities. Costs. Fees, including attorney's fees, and costs in connection with any third-party allegation or legal proceeding in a case arising out of or in connection with to the advertisement's targets, destinations, services, uses or any breach by customer of these terms. The partners are the intended third-party beneficiaries of this section. 12. Changes to the terms. Google may make minor changes to these terms at any time without notice, but Google will notify you in advance of any material changes to these terms. The terms will be posted at www.google.com/ads/terms. Changes to the terms will not be applied retroactively and will become effective 7 days after they are posted. However, changes made for legal reasons will take effect immediately upon notice. Either party may terminate these terms at any time by giving notice to the other. But advertising campaigns are not canceled under Section 5 and new advertising campaigns remain in effect. May run and be reserved and continued use of the program is, in each case, governed by Google's applicable terms and conditions for the programs, currently posted on www.google.com/ads/terms. Google may suspend customers' ability to participate in the programs at any time. In any event, the running of any advertising campaign by customer following termination of the terms is entirely at Google's discretion. 13. Dispute settlement agreement. A negotiate. In the event of any dispute arising out of or relating to these terms, each such dispute shall be referred to as a dispute. The parties will endeavor in good faith to resolve the dispute within 60 days from the date of receipt of written notice of the dispute from the other party. If the parties are unable or unwilling to resolve the dispute within that time, the dispute shall be finally decided by arbitration administered by the International Center for Dispute Settlement, ICDR, under the ICDR's Rules of International Arbitration, hereinafter referred to as the rules. This arbitration agreement is intended to be broadly construed and, among other requirements, to apply to any claims brought by or against Google. Its Google affiliates offer programs to customers or advertisers, Google's parent companies, and their officers, directors, employees, agents, predecessors, successors, and recipients. Respective transfers of these organizations and client or advertiser, affiliates and parent companies of client or advertiser and their officers, directors, employees, substitutes face, predecessor, successor and respective assignee of these organizations. B. Arbitration proceedings. The venue for the arbitration shall be Santa Clara County, State of California. The arbitration shall be conducted before an arbitral tribunal consisting of 3 arbitrators. The claimants shall select one arbitrator of the arbitral tribunal in accordance with the rules, and the respondent shall jointly select a second arbitrator under the rules. If the parties fail to agree on a third arbitrator, hereinafter referred to as the chairman, within 20 days of the confirmation of the second arbitrator, ICDR will appoint the chairman in accordance with the rules. The arbitration will be conducted in English, except as may otherwise be provided by law. The existence, substance or outcome of any arbitration, including any documents or evidence presented, shall be kept strictly confidential. The decisions of the arbitrators shall be final and binding, and judgment in respect of any decision made by the arbitrators may be submitted to any court of competent jurisdiction. With those decisions, the arbitrators shall not be bound by awards in other arbitration proceedings to which the client or the advertiser is not a party. The arbitrators shall have the power to make statements determining an emergency right or relief, whether provisional or final, solely for the benefit of the individual requesting the relief and only to the extent necessary to provide a deterrent justifiable by the individual party's request without affecting other Google users or other customers or advertisers. And any interim measures under the orders of the arbitrators may be enforced by any court of competent jurisdiction. Nothing in these terms shall prevent either party from seeking personalized interim or preliminary relief from any court of competent jurisdiction, and any application to the court. Such personalized provisional or preliminary imposition of a judgment shall not be deemed to be incompatible with the agreement on arbitration or as a waiver of the right to participate in the arbitration. C. No class arbitration proceedings. Customers, advertising party and Google agree that each party may be made claims against the other party only, and not as a personality in the country of in one of the countries only, and not as a partner community celebration, representative OR authorization for the benefits of the community. Google, customer and advertiser agree that, by entering into this arbitration agreement, Google client and advertiser waive their respective rights to adjudication by panel or to participate in class or representative legal action, unless all affected parties agree otherwise in writing. Arbitrators may not preside over any form of representative or class action. If the court determines that applicable law does not permit the enforcement of any restriction in this subsection for a particular relief request, that request, and only that request, must be severable from arbitration and may be taken to court. 14 other terms. All requirements arising from OR in related to the terms OR programs will be subject to the law of the State of California, excluding the rules of the State of California, District of California. California legal law for OR has lower priority than U.S. federal law. B. Except the case of Section 13, only in the case of Section 13 unexpected on a particular claim OR dispute. All claims arise from OR in connection with any of the above. The program will be customized only in federal courts or state courts of Santa Clara County, State of California. The parties agree to personal judgment in this court. C. Customer shall not seek in any manner any proceedings filed during the time these terms are in effect, and for 1 year after termination of these terms in any way, a remedy. Deterrent based on patent infringement related to the programs. D. These terms are the entire agreement of the parties relating to the subject matter of these terms and supersede any prior or contemporaneous agreements with respect to such subject matter. E. Customer is not permitted to make any public statements about the relationship covered by these terms, unless required by law. F. All notices of termination or breach, or under Section 13, shall be in writing and addressed to the other party's legal department, or, if it is unclear whether the other party has a legal department, must be sent to the other party's primary contact or other address on file. The email address for sending notices to the Google Legal Department is legal-notices@google.com. Any other notices sent to the client will be in writing and sent to the email address associated with the client's account. Any other notice to Google must be in writing and addressed to customer's primary contact at Google or by other means available to Google. Notice will be deemed delivered upon receipt. as confirmed in writing or by electronic means. These notice requirements do not apply to service of subpoenas that are governed by applicable law. G. Except for modifications made by Google to these terms under Section 12, any modification must be mutually agreed to by both parties and must expressly state that it amends the terms. This account, no party shall be deemed to have waived any right by failure to exercise, or by delay in exercising, any right under these terms, except as provided in Section 13, c. If any provision of these terms is determined to be unenforceable, that provision shall be forfeited and the remainder of the terms of shall remain in full force and effect. H. Neither party may assign any part of these terms without the prior written consent of the other, except in the event that a. Google may assign all or part of the terms. Google's rights and/or obligations under these terms to the affiliated company if Google has notified customer of such transfer. And b. Customer may assign all rights and obligations customer's obligations under these terms to an affiliate, but only if I. The assignee agrees in writing to be bound by these terms. 2. The customer remains liable for obligations under these terms if the transferee fails to perform its obligations under these terms, and 3. Customer has notified Google of such transfer. Any other attempt to assign or transfer is void. Except as expressly set forth in Sections 11 and 13, there is no third-party beneficiary to these terms. These terms do not create any agency, partnership or joint venture relationship between the parties. Sections 1, last sentence only, and 8 through 14 will continue in effect after termination of these terms. L. Except for payment obligations, neither party nor its affiliates shall be liable for non-performance or delay in performance caused by circumstances beyond its control. Reasonable control of that party. If these terms provided in English and any other language, the English version shall prevail in the event of a conflict. This notice contains the word September 1, 2017. We just read verbatim the Google Advertising Program terms. For you to listen, if you find it interesting, please thwang tin subscribe and click like and share this video for many people. Sincerely thank.